I want you to picture something before we begin. Picture a woman who has never once, in 51 years of living, stood in a room where her comfort was not the first priority. A woman who has been accommodated so completely for so long that accommodation has stopped feeling like a courtesy and started feeling like a right. A woman who has walked into restaurants and been seated immediately, into stores and been attended to instantly, into conversations and been agreed with reflexively for so many years that the experience of being told no has become genuinely foreign to her. Not frightening, foreign, like a word in a language she was never taught because no one around her spoke it. Now picture that woman walking into my courtroom. On the morning of February 11th at exactly 10:22 a.m., Margot Delacroix, wife of Thomas Delacroix, founder and chief executive of Delacroix Logistics Group, a company with operations in 11 states and a valuation that made the local business press salivate every quarter, walked through my courtroom doors 18 minutes late, looked around the room the way you look around a restaurant you are not sure is good enough for you, and sat down. She did not apologize for the delay. She did not acknowledge it at all. And what happened in the next 40 minutes is something I have thought about every week since February 11th, because it contains in compact and precise form everything this bench exists to demonstrate. Subscribe to this channel right now before we go any further and turn on notifications, because this is exactly what we bring you every single week. Stories from this bench about what happens when the room someone walks into turns out to be different from every other room they have ever entered. Drop a comment before we continue. Tell me, have you ever watched someone discover in real time that their usual tools did not work? Tell me what that looked like. Tell me whether you felt sorry for them or not, because what you are about to see will make that question more complicated than you expect. Now, let us begin. The plaintiff before this court was a woman named Celestine Okafor, 43 years old, born in Lagos, Nigeria, arrived in this country at 22 with a degree in accounting, a reference letter from a professor, and the specific kind of determination that does not announce itself because it is too busy working. She had spent the following 21 years building a bookkeeping and financial services practice from a desk in her apartment, then a shared office, then a suite of 4 rooms she signed the lease on herself on a Tuesday morning and stood inside alone for 10 minutes before her first employee arrived, just to feel what she had built. By the time she came to my courtroom, Celestine Okafor employed 7 people. She had a client list of 34 small and mid-sized businesses. She had a reputation in this city's business community that had taken 21 years to construct and that rested entirely on a single foundation: that she was honest, that her numbers were accurate, and that she did what she said she would do. Margot Delacroix had hired Celestine's firm 18 months earlier to handle the personal financial accounts of the Delacroix family, separate from the corporate accounts managed by the company's internal team. Specifically, the household accounts, the charitable foundation disbursements, and Margot's personal discretionary funds, which ran, according to the contract, to a monthly figure that made Celestine's entire annual revenue look modest. For 14 months, the arrangement worked. Celestine's firm filed the reports, tracked the disbursements, flagged the discrepancies, and delivered the documentation on schedule every month, without exception. Then, on the morning of the 15th month, Margot Delacroix terminated the contract by email. No notice period, no explanation. A 4-line email sent at 11:47 p.m. on a Sunday, stating that the family would be transitioning to a new financial services provider effective immediately, and that Celestine's firm should consider its engagement concluded. The final 2 months of contracted fees, $34,000, remained unpaid. Celestine sent 3 invoices. She received no response. She had her attorneys send a formal demand letter. She received a response from the Delacroix family's legal team. 2 paragraphs stating that the contract had been terminated for cause due to performance deficiencies and that no further payment was owed. There were no performance deficiencies. There had never been a single documented complaint in 14 months of service, no missed deadline, no inaccurate filing, no unreturned communication, nothing. The termination for cause claim had been invented, as a document trail would later make clear, specifically to avoid the final 2 months of payment. Celestine Okafor did not accept that. She retained her own attorney. She filed suit. And the case came to my courtroom on February 11th. Margot Delacroix arrived 18 minutes late. She arrived without her husband, which I noted. Thomas Delacroix, whose name was on the original contract, whose signature appeared on the agreement, was not present. Margot had decided, apparently, that this was her matter to handle and that she was capable of handling it in the same way she handled everything else in her life, through the application of sufficient confidence and the implicit threat of sufficient resources. She sat down at the defendant's table and immediately began whispering to her attorney, a senior partner from a firm whose retainer alone exceeded what most people in this city earned in a year. The attorney was a man named Preston Holt, who had, I knew from prior proceedings, a particular talent for making straightforward matters feel complicated through sheer volume of documentation and procedural motion. He had submitted before this hearing 4 separate motions to dismiss on grounds that ranged from jurisdictional questions to contract interpretation disputes so technical they required a glossary. I had reviewed all of them. I had denied all of them. I called the case. Celestine Okafor's attorney, a woman named Janet Kwan, who was precise and fast and entirely without unnecessary decoration, presented the claim in 11 minutes. The original contract, 14 months of documented, uncontested work product, the invoices, the non-response, the termination for cause letter, and the specific detail that I want you to hold in your mind. She presented an internal email chain from within the Delacroix household staff, obtained through discovery, in which Margot Delacroix wrote to her personal assistant 12 days before the termination email, asking how to end a contract without paying the remaining balance. The assistant had responded with several options. Margot had chosen the termination for cause route and written, in her own words, that one. Performance issues are always believable. That one. Performance issues are always believable. I want you to sit with that sentence for a moment. A woman wrote those words in an email about a service provider who had done her job flawlessly for 14 months and sent it and did not consider the possibility that anyone would ever read it in a courtroom. That is not incompetence. That is the specific blindness that comes from never having been held accountable for anything. I looked at Margot Delacroix. She was looking at her attorney. She had not looked at Celestine once since entering the room. I said, Mrs. Delacroix, I would like to give you the opportunity to respond to the claim. Her attorney rose immediately. He spoke for 7 minutes, citing the contractual language around termination clauses, arguing that the email in question was taken out of context, suggesting that the discovery process had exceeded its proper scope, and requesting that the court consider the totality of the business relationship rather than individual documents in isolation. It was, technically speaking, competent. It was also completely detached from the internal email, which was not ambiguous, which was not out of context, and which had been written by his client in her own words. When he finished, I said, "Thank you, Mr. Holt. Mrs. Delacroix, I would like to hear from you directly. The email submitted as Exhibit 7 was written by you. Is that correct?" She looked at me for the first time, not at her attorney for guidance, at me. And what I saw in that look was not nervousness or calculation or even arrogance exactly. It was something more specific than arrogance. It was the settled, unexamined certainty of someone who had simply never been in a room that required her to account for herself. She said, I'm sure my attorney has addressed all of that. I said, he has offered an interpretation of it. I am asking you directly whether you wrote it. She said, I don't really see how that's... I said, Mrs. Delacroix, did you write the email in Exhibit 7? She looked at me with a quality of mild surprise, as if the insistence itself was the strange part. Then she said the sentence that I want you to remember. The sentence that, as I told her afterward, she should have spent considerably more time considering before she said it out loud in a court of law. She said, with respect, Your Honor, I don't answer to you. The courtroom went completely still. Not the restless stillness of boredom, the specific, pressurized stillness of people who have just watched someone step off a ledge in slow motion and cannot yet determine how far the fall is going to be. I removed my glasses. I said nothing for a full 4 seconds. I have learned in 38 years that silence in a courtroom is a tool and that its weight increases with every second it is allowed to sit. Then I said, Mrs. Delacroix, I want to make sure this court has heard you correctly. You have just told me in an open proceeding that you do not answer to me. I want to address that with the precision it deserves. I said, this courtroom is not a restaurant. It is not a charity gala. It is not a board meeting where your husband's title determines whose opinion carries weight. It is a court of law. And in a court of law, Mrs. Delacroix, every person who sits in that chair answers to this bench, regardless of their net worth, regardless of whose name is on their building, regardless of how long it has been since anyone in their life required them to answer for anything at all. I looked at her steadily. I said, you will answer my question. Did you write the email in Exhibit 7? The smile, and there had been a smile, small and practiced, the smile of someone performing calm, was gone. In its place was something I had watched arrive on many faces over many years, the dawning understanding that the room was not going to move around her. She said, quietly, yes. I said, thank you, and the phrase, performance issues are always believable. That is your language? A pause, very long, the kind of pause that is its own answer. She said, yes. I said, so this court understands correctly that you selected the termination for cause option, not because there were documented performance deficiencies, but because, in your own assessment, such deficiencies would be believable as a reason, whether or not they existed. Her attorney stood. I held up one hand. She said nothing. I said, your silence is noted, Mrs. Delacroix. Let me tell you what this court finds. I find that the termination for cause was manufactured. The evidence for this is not circumstantial. It is documentary. It is in your client's own words, written by her own hand, preserved in a discovery record that she apparently did not anticipate would be read aloud in a proceeding she apparently did not anticipate would require her to answer for herself. I said, Celestine Okafor worked for your household for 14 months. She filed accurate reports. She met every deadline. She returned every communication. She did the job she was contracted to do without a single documented complaint from your side for 14 months. And then, when the contract reached its final 2 months, you chose to avoid the remaining payment by attaching a false cause to the termination because, as you wrote yourself, performance issues are always believable. I said, they were not, in this case, believable to this court. Here is the judgment. You will pay Celestine Okafor the full outstanding contract balance of $34,000. This is not a negotiated resolution. This is the debt you owe for services rendered and received and deliberately not paid. You will pay an additional $18,500 in bad faith litigation damages because this court does not view the filing of a false termination for cause, the refusal to respond to 3 separate invoices, and the deployment of a senior partner to bury a straightforward payment dispute under procedural motions as a good faith defense of a legitimate position. It views it as the use of resources to avoid an obligation, which is not a legal strategy. It is a choice, and it has a cost. You will pay Celestine Okafor's full legal fees because she should not have had to spend money to recover money she was owed for work she had already done. The total judgment against you is $61,700 plus court costs. Margot Delacroix was looking at the table in front of her. The practiced calm was entirely gone. In its place was the particular stillness of a person who had entered a room as one version of themselves and was going to leave it as a slightly different one, whether they chose to be or not. Her attorney was already leaning toward her, speaking quietly. She was not listening to him. I said, "Mrs. Delacroix, I want to say one more thing before we conclude." She looked up. I said, "You told me earlier that you do not answer to me. I want to revisit that. You were correct that outside this building, in the world you occupy, that statement may function as true. You have resources, you have representation, you have a name that opens rooms, and a position that has, for a very long time, meant that consequence was something managed on your behalf before it reached you directly." I said, "Inside this building, that sentence has a different meaning. Inside this building, everyone answers. Not to me specifically, to what I represent, to the idea that what you owe someone for work they have done is not optional, that a contract is not a suggestion, that a woman who spent 21 years building something honest deserves to be paid for the honest work she did, regardless of whether the person who hired her has grown accustomed to a world where that kind of thing can be managed away." I said, "Today, it could not be managed away. I hope that is instructive." The gavel came down. Celestine Okafor sat very still for a moment after the judgment. Then she gathered her documents, stood, and walked out of the courtroom with the same composure she had walked in with, the composure of someone who had spent 21 years doing the work correctly and had simply needed one room, one morning, to confirm that it had mattered. That is what justice looked like on February 11th. Not a dramatic speech, not a broken woman in an expensive coat. A 43-year-old woman who came to this country with a reference letter and a determination that did not announce itself, walking out of a courtroom with $61,700 she had earned, and a verdict she had waited 14 months for. And a woman who said, "I don't answer to you," learning in exactly 10 seconds what that sentence costs when you say it in the wrong room. If you believe that what you owe someone for honest work is not optional, that confidence without accountability is not strength, and that there are still rooms in this world where the size of your husband's company does not determine the outcome, hit that like button right now, subscribe to this channel, and leave a comment below. Tell me, have you ever done honest work for someone who tried to avoid paying you? Tell me what happened. Tell me whether you fought it. Justice does not ask whose name is on the building. It asks what you owe and whether you paid it. Choose honestly every single time. Choose wisely.